Let me introduce the speaker for the next Insights session. Mr. Ashok Ram Kumar, sir, is the founder and senior partner at Wordict-IP. With 36 years of expertise in intellectual property and over 6,000 IP applications, he is a designated senior counsel and a leading voice in IP litigation, enforcement and anti-counterfeiting. Now I request Ashok Ram Kumar sir onto the dais.
When Mr. Moksha asked me, saying, sir, you need to talk about something, I said it's dangerous to give a mic to a lawyer because we can hold the fort for the whole day. Anyway, the IP Day is celebrated every year, right? On 26th, whatever is the day. But this time the theme is music and IP. I was seeing the slideshow she was presenting and asking questions. So before I get into this, for the sake of simple enlightenment, I would like to tell you what applies to what. Very simple. You don't need to get confused at all. Unfortunately, sometimes the lower court judges also don't understand this. That's the difficulty. Let me take my cell phone. This is a cell phone. You know the multiple IPs this cell phone has got. Now, the Samsung is a trademark, right? Trademark is for a graphic representation, for a word, logo. Now you have trademarks for smell, you have trademarks for sound, right? You have trademarks for shape. In fact, the Coca-Cola bottle there is now no design on Coca-Cola bottle. Very smartly what they did, after the design expired after 15 years, because design is only for 15 years, initially given for 10 years, extendable by 5 years. After the design period expired, the company thought of a lifelong protection for the bottle. So now the Coca-Cola bottle has got a shape mark. Even shape can be a trademark, right? So that is with regard to the trademark. Next is design. In US we call it as design patent, but in India we just call it as design. Design is for the aesthetic feature of any object. Aesthetic feature. So if my phone has got round edges, that could be a design. I can remove this, make the edges sharp, refile an application, right? So design is for a three-dimensional object. No functionality, only aesthetic look. Remember that. When your design is infringed, you can't go to the court and say, this works this way. You will not get an injunction. Quite recently, I filed a suit I filed a trademark for a shape mark being a nut, a self-locking nut that is used for railway tracks on bridges. Now what does this nut do? Functionality of the nut is to see that the rails don't move. It takes the vibration, consumes the vibration in the spring that is there inside the nut, and then it retains the position of the rail so that it does not move. Very simple technology. I am now filing a patent for it. I got a trademark for it. Someone, I go for tenders to the railways. Someone also filed a similar tender with the railways saying, we are also manufacturing this. So I immediately had to rush to the civil court. I could get an injunction based on the shape of the mark, right? So design, I can also file a design for that. Now there was one very interesting case which I handled for a company called as Autocracy. They are manufacturers of various machinery. There was a suit filed against me by some Delhi party saying you have copied the design of a harvester, a sugarcane harvester. Well, on technical grounds I got the injunction removed because I was not served the papers completely. So I said papers were not served on me. So the Order 39 Rule 4 has not been complied properly, remove the injunction was removed. When it came for argument, I took a very simple ground. Every design application, remember this, a substantial design application will contain 7 images. Now what I am telling you is a secret. I'm not charging you anything for that. It contains 7 images of the product. Top, bottom, left, right, front, back. There is 6 images, and the 7th image is called as a lateral image. That is, you put the object, see 3 sides of the object come in the picture, take the picture and file it. This is called as a comprehensive design application. Any design application that does not have these 7 features or 7 pictures, you can seek for a cancellation of it. Now when I say cancellation, let me be very clear. No intellectual property is permanent. I'll tell you that later. Why it is not permanent. That is with regard to design. With regard to patent, patent is for a product or a process. That's all. A plus B plus C is equal to D. I get a patent for D. You can't use any other procedure, X, Y, Z, to manufacture D because D is patented. That is product patent. Process patent is A plus B plus C is equal to D. I get a patent for A plus B plus C. I can use X plus Y plus Z and manufacture D. I am not infringing. But I can't use A plus B plus C to manufacture D. Right? And to put it very simple, product patents are very strong while process patents are weak. That is with regard to patents. Now coming to copyright. Copyright is for an expression. Remember one thing very clearly under copyright law. This is what I always tell when I argue in the courts. Copyright is not for the idea. It is for the format. How you have written. Ramayana has been written by so many people. All of them have got copyright. Now Vyasa can't come and say, no, you can't. Our first president wrote a beautiful book on Ramayana. So the doctrine of idea expression dichotomy, which is very important. Then you have other intellectual property like geographical indication, appellation of the region like Kanchivaram Patte from Kanjivaram, right? Then you have the plant varieties, then you have the farmers' rights, then you have the traditional knowledge, then you have the trade secrets, right? And intellectual property has got 4 important pillars. One is filing and prosecution, where you file an application, prosecute it to the logical end. The second is enforcement. Enforcement is most important. Enforcement is what? Protecting the IP in a court. Someone is infringing your mark, someone is infringing your patent, someone has copied your design. So how do you approach the court? Get a relief to your client. That is enforcement. Valuation, right? Valuation of an IP. How much do I value this phone? And the final one is called as monetization. Now don't get confused between valuation and monetization, both are different. Monetization is when I introduce this product in the market. When the product is introduced in the market, how much do I sell this product for? Right? So these are the 4 important pillars of IPR. Now I wanted to tell this because that after I saw that puzzle, this thing, I thought I should share this because frankly speaking, ignorance of law is no excuse for anyone. Not just the lawyers, not just the judges, even for anyone, ignorance of law is no excuse. Now, on today's topic, music is a very important part of life. I'll only relegate myself to a very simple issue that I've been dealing with since 2014. It's an issue that in fact my very worthy adversary Mr. Suresh is there. He always appears against me in PPL matters. The issue pertains to, can I play a song for a function? Can I play a song for an event? What should I do when I play a song? The Copyright Act envisaged certain bodies called as copyright societies that comes under section 33 of the Copyright Act. Now what does a copyright society do? That was a very noble thought when it came. What they do is, when you are playing a particular song or playing a particular thing, they collect royalty from you, and after deducting the administrative charges there, they pay the royalty to these artists. That is the noble cause for which it was. Now that was completely mismanaged. There were lots of cases filed in the Supreme Court where they said they made a lot of money. When I am paying the money, is it really going to the artist? All this. This issue of playing music, this went on since 2014, and I had been very vehemently opposing this on two important grounds. One, I am not a pirate. I don't want to copy your song and play it. Two, I will pay the money. But to whom should I pay the money is a question. Now, each copyright society is for only one work. Now, when this amendment happened in 2012, which is a very important amendment, the copyright societies of PPL, Phonographic Performers Limited, and IPRS, they both came out of being a society, but they started acting like copyright societies under Section 30, which they say is applicable to them. Only on one simple ground, they say, look, I have assignment deeds in my favor. I have the proprietary right in the song that has been given by the label to me. So I can extend my hand and I can ask you to take a license, and I can ask a royalty to be paid. But the first hurdle came in the case before the Chennai High Court for DXT Technologies, where Novix, which considers itself as one of the rights holder for sound recording, they went to the Chennai High Court, and then they said, these people are not paying, please direct them to pay. Then that judge, he took a objection. He said, look, how are you asking for this? Because Section 18 of the copyright says assignment can only be done to a copyright society. Rule 44 says only a copyright society can be in the business of granting license. So how do you come there? He didn't give an order there. He in fact dismissed their suit. So Novex cut the branch on which they were sitting. Quite recently, just hardly about a week or 10 days back, that was music to my ears. There was a suit filed in Delhi by PPL, which is the second. The single judge gave an injunction to PPL saying, yes, you have the right to collect royalty and issue license, because I recognize the assignment agreements done by various labels in your name and you are an owner of that. Then the Azure Hospitality, which is a very famous hotel chain, they went in appeal in the High Court, a division bench. Two judges said that. So there, the division bench straight away set aside the single judge judgment, saying, look, you cannot be in the business of issuing license. Forget about collecting royalty. You just can't be in the business of issuing license. Then PPL also did not keep quiet. They went to the Supreme Court. Now, this is where the entire scene changed. An order was passed, interim order. What happened? The Supreme Court said, I'm not giving effect to the single judge order, which means injunction is not going to support you. Then the Supreme Court also said, like the way how the division bench said, you become a member of RMPL, because under Section 33 of the Copyright Act, there can be only one society for one nature of work. You can't have multiple societies. You become a member for RMPL and you charge whatever charges RMPL is charging. Because there was a complaint against Novex and PPL saying they charge exorbitantly. So now, today the scene is, PPL does not have an injunction in its favor because of the single judge order not being enforced. And the Supreme Court said, you go to RMPL, become a member, then you start charging. So whoever is doing the functions now can literally use PPL's music without paying a single paisa. That is the situation now. Now, why did I give you the example is, this is the sort of fight that goes on in the music industry. This is only one module of that, right? You have cases like Ilayaraja's case, then you had so many other cases. In all this mealing, in all this confusion, you also have an exemption under Copyright Act under Section 52, right? Now, why is it that these sort of occasions are important? Why is it that we Sir has come, spoken, you have further speakers. Innovation and invention drives this world. Remember that. Innovation and invention adds to the intellectual capitalism of this country. It is an encouragement for your neighbor to do a better invention, right? So thank you so much. And any doubts, you can address it to Mr. Moksh. I'll be willing to answer that. Thank you.
The theme and the session is yours.
Are we seeing courts becoming more sensitive to the nuances of music and copyright infringements?
How do you say that a song is original?
I gained a lot of knowledge today. Thank you.